attendance this morning. That's great. Morning, everyone. Good morning, Mr. Young.
Morning, Judge.
Okay?
I'm doing fine, thank you.
Yep. We missed you at our meeting Monday. But if you had an excuse, yours was pretty good. So Judge Navarre, I see, Mr. Martin, Representative Leland. Have you been to any Columbus games?
We start our home season on the 11th.
Baseball's back in Toledo this past Tuesday. All is right with the world, at least
All's right with the world.
in the 6th district. Judge Savaggio, you have the documents now. Doug DeMolt, good morning.
Good morning.
We got information that your boss was intending to attend. Are you aware of that?
Yeah, I talked with him this morning. He should be logging on here in a few
Okay,
minutes.
excellent. That's great. I'm happy to have his participation. Ms. Miller, Mr. Godsey. Sarah, how are you? Hi, Andy Wilson. I just want to see who else is here. Joanne Sanchez, Judge Navarre, I already said hi to. My idol, Judge McIntosh. Senator Gavarone, thank you for joining us. We still need to get together, and we shall. And then Judge Bergeron. All right. Brian, who are we missing? And it looks like a pretty full complement, is it not?
It is pretty full. I think we're good to start.
I think we are too. So we started 2 minutes late in letting you all in because there's another transition that's happening internal to the court, but is impacting us a little bit. Some of you should see, or all of you should see, two windows. One has the name Michael Woods on it. The other one, which is the giant gavel with Dean Hogan's name. Those are the tech people from the Supreme Court that help have all of this flow. Michael Woods has been assigned to this task force since its beginning. He is stepping out of employment with the Supreme Court and has found a position in the federal government. So this is his last meeting, and he's handing things over to Mr. Hogan, very capable body. And so we'll wish Michael a fond goodbye and thank you for all your hard work, and welcome Dean to this task force. With that, then let's begin. Let me pull up. Okay, first order of business is the approval of the April 16, 2001 minutes. All of you should have received copies of them. Are there any, first of all, any motions for clarification amendments to the minutes that have been submitted for review? Seeing none, is there a motion to approve?
So moved.
So moved.
All right, second?
Second.
Second. I'm sorry, I missed the second. Who seconded? I missed that.
Second.
Oh,
Second.
Representative Leland, thank you.
Yeah.
All right. All in favor signify by raising your hand. Aye. Any opposed, same sign. Seeing none, passed unanimously. Thank you very much. You will also see 3 articles, as I've expressed in the past, my commitment that as I become aware of stories that are pertinent or relevant to the task force, we'll include them in this section. Hopefully you've had a chance to review or will review those articles as we move forward with this task force work. Finalizing recommendations on changes to rules and statutes. So each of you should have received what I call a synthesized criminal rule 33.1. That would have been attached to and included with the material when we sent out notice of this particular meeting. So we sent out the minutes and the like. We sent out what I'm calling a synthesized criminal rule 33.1. The reason I'm calling it that is because what we, and when I say we, I mean Brian, Catherine, and myself. After our last meeting, we went through the meeting, the minutes, and based on that, we cobbled together what we thought was a consensus draft of where we thought the committee was essentially at as it relates to 33.1, and to frame it in such a way that we could move forward in seeing whether or not we can reach consensus in approving a draft new model rule or not. And that's why I call it a synthesized criminal rule 33.1. After that was sent out, I became aware yesterday, as a matter of fact, yesterday morning, that a group of task force members had been working either, and I'm not sure, it doesn't really matter whether they were working on their own draft or were reacting to the synthesized draft that we had submitted to you for consideration this day. And when I saw it, I reviewed it myself. Brian and I and Catherine reviewed it, and I felt it important enough that we share that with you, which is why you should have all received a copy of that subsequent draft yesterday morning, with also an indication that if there were any other potential drafts that would be of interest or that were being considered by other task force members, to please submit them to us prior to 3 o'clock yesterday so that we could review them ourselves and be in a position to present them to all task force members prior to the commencement of our meeting today. We've not received, Brian, I want to make sure you didn't send me any, so I assume we did not receive any other drafts from anyone else.
I did not receive any other drafts.
Okay, all right. So can we pull up both drafts simultaneously so we have the two versions?
I don't know that I can make both of them show at once.
Pull up the subsequent draft then. Because the subsequent draft shows the modification of our synthesized draft.
All right, is that showing for you?
Yep, I have it. Everybody can see that, right? I guess, okay. Yeah, so the struck language is what was in the synthesized draft, and then what we've received now is this new language. So as I looked at this, there's an interesting distinction between changing the phrase "not introduced at trial" with a phrase "not considered at trial." And as I have thought that through, I think it's an important and valid consideration. So I'm prepared to just proceed with vetting this document in front of us right now, because I think it certainly incorporates the bulk of what we attempted to accomplish with our synthesized version. And the other distinction between whether or not it's affidavit evidence versus supporting materials, I'm comfortable in going forward with just this draft for purposes of seeing whether or not we can reach consensus as a draft rule to recommend for our consideration going forward. Discussions with anyone? Your viewpoints on this? Any objection, I guess, is the better way of putting it?
Gene, can I ask a question?
Sure, Judge.
Yeah, just if I could get a sense, I guess, for the members as to how they interpret not considered or not introduced. Would something that was offered but the court would not allow in be something that was not considered at trial or not introduced at trial?
That's a really good question.
I mean, I would hope something like that. I mean, on direct appeal, would be dealt with. But if on direct appeal, it's affirmed as to the judge's decision,
Then
could
it's-
it be raised later as something that was not considered or not introduced at trial? And so I just
Well,
want to kind of get the sense of everyone.
Right. So, okay, I certainly have an opinion of that, but I'll defer if someone else wants to comment first, their view of that language.
Perhaps
Perhaps
trial judge should, so you could then reverse this on appeal, Gene.
I'm sorry?
I said probably a trial judge should talk, and then you can reverse this on the appeal. But I would look at it, it says not previously considered. So if it were offered and excluded by the trial judge, then that is a matter for direct appeal.
Right.
Or a post-conviction relief on an ineffective assistance of counsel. It would not be, in my judgment, a grounds for a new appeal or a new trial under 33.1. I would think it would have to be evidence that was not offered or brought to the court's attention in any way. And it may not have been known either. So that was certainly, covered. But I don't think it covers evidence that was attempted to be introduced and was excluded.
Yes, but proffered into the record.
Well, yes, yeah, it would have to have been proffered in the record of some sort. I mean, either, offered and the objection is sustained or excluded by a pretrial ruling or something of that nature.
Right. Because this probably doesn't happen in Highland County, but believe it or not, I've seen cases where an effort is made to introduce certain evidence, trial court makes a decision, doesn't allow it, but then it's not proffered either. So, and
Yeah.
then, so I think that would be excluded. Anyone else want to comment about this? This seems to narrow. So what I think Rocky is saying, that the current language that's before us actually narrows the area of what could be considered under a 33.1 motion. Anyone else?
Just real briefly, I think I would actually say that it expands it considerably, because there's no requirement that, well, first of all, not introduced at trial and not considered at trial. There's I do agree it's an important distinction. One of the concerns I have, though, is not considered at trial is considered by whom? Is this going to open the door to whether or not the jury considered a piece of evidence or not? How do we know what they considered? And that leads down the road to some dangerous inquiries in determining who actually considered it. When you have the threshold issue at introduced, it's a clear, bright line test of whether or not the evidence was there or not. I have some significant issues, like we previously discussed, about how I think overbroad A is here at this point. But I think that not considered at trial is rather it's a difficult line to draw without some more clarification in here.
All right, thank you, Doug. Anyone else? Mark, I know you had your hand up. Mr. Gotzi? And then Judge Simon.
I mean, the change was, I was one of the people that made the change, and we thought that the prosecutors would balk. We were attempting to narrow it. I mean, correct me if I'm wrong, Joanna, and others who were involved in that discussion. And the thought was, what if the defendant tries to offer something and it's not accepted by the court? He can't come around 10 years later and claim that's new evidence. So we were trying to make it considered, like, was it brought up at trial? That was just the thought process behind it.
Okay, so it is an attempt to narrow the scope of what can be considered under a 33.1 motion.
Could the wording be changed and instead of considered, say not proffered at trial?
You could say that, although if you're going to say that, I think you need to say either proffered or admitted.
And maybe not just at trial, but in the trial or any proceedings, because if there was a motion in limine and it was excluded, the counsel forgot to try to bring it up again in the trial to protect the record, that would still show that it had been brought up, and it then puts it in the issue of direct appeal or ineffective assistance of counsel on a post-conviction.
All right, so Judge Savaggio?
But I was just gonna note that, when we're creating any new rule, we want to, I think, construct something that is as user-friendly as it can be. So this debate that we're having is really one of a measuring stick for the trial judge. How do we measure what is relevant and admissible evidence? And so whether, we land on not considered or not introduced or not sought to be introduced or not proffered, the perspective is how user-friendly is this? It's the same concern that I would have with the definition of patently frivolous. What are we actually saying when we say could be tested at a hearing? And so to the extent that we clarify, I like Mark's idea of narrowing the scope, but I think consideration is too nebulous. To suggest that it be introduced or sought to be introduced can be actually measured from the record. The way that we have considered, it depends on who is considering it, who is the individual that is considering it. And then I have a secondary issue to raise, but I won't do it during this discussion. I'll wait till this topic is over.
Okay. We'll come back
As a
to
quick-
the other issue then. Mark?
As
did
a
you want
quick
to
follow-up
respond?
real quick, I'm sorry, Judge Samuda, but on this, isn't this issue introduced because we took away the newly discovered evidence requirement, that the evidence be newly discovered? Because that used to be the gatekeeper threshold issue in prior drafts. And so this was kind of a problem of our creation here when we removed that, isn't it?
You may be correct. I know based on discussions at our last meeting, there was more of a consensus, I felt, based on everyone's input for the language that we had submitted to you. And at this point, we're just really trying to deal with not considered at trial or not introduced at trial. I'm curious about the reality of not considered at trial being anyone other than who determines what is considered a trial, but the trial court, obviously, right? And the parties' counsel have the prerogative or the ability to suggest to the court, we would like this to be considered. So it's the trial court as the gatekeeper based on what the attorneys are attempting to allow or get into for consideration. A jury doesn't have any determination of whether it will or won't consider it. That's the judge who makes that determination. So I don't know if it's really makes it a more broader statement to say not considered at trial versus vis-a-vis not introduced at trial. Mark, you had your hand up. Did you want to clarify anything for us? Responsive to somebody?
I mean, I just left it up from before, but I personally think not considered is limiting it more than introduced, but I understand the point that's being brought up. I mean, maybe we could say something like not part of the record at trial, or not introduced or sought to be introduced, which is what somebody else said.
Okay. Let me just proffer this, because I think perspective is really important here. I know that we don't necessarily have unanimous support for every facet of every component, even of this rule, all right? But I do think there is support to recognize that, number one, a rule such as 33.1 is something that we unanimously support. And then the issue becomes, well, what's the detail of that, right? And I think what we try to do sometimes is we're trying to create a rule that is so ironclad that it ignores the reality of what it means to practice law in Ohio. And that is, it really is framing an issue to give guidance and direction, but not tying the hands of the trial court judges, right? You can't create a rule that you think is going to eliminate any discretion because it specifically says that, because I think the vibrancy of the English language and the intelligence of lawyers and judges is such that they can argue around it. I mean, I think all we really have to do is think about the arguments, and they're all valid and, you know, sincere in the discussions we've had over the last 3 months relative to this issue to demonstrate that. So I look at what do we have now? Nothing as it relates to claims pertaining to actual innocence. And what this does, I think, for the first time, is it attempts to articulate a framework by which those claims should be considered and processed. Okay, and that's why the procedure part, which we haven't gotten to, I understand that. But I think the grounds section, I don't know how you can clarify it any more than what you say, either not considered or introduced at trial. I think not considered happens to be a tighter fit, but I don't know any other wordsmithing of language that's going to make it more precise than that, given how the process actually works. A judge will make that determination, for example, whether or not on a 33.1, is it items that could have been considered at trial or would have been considered at trial, but to allow it to come in under a 33.1 or not. A trial judge will say yes or no if that issue is raised. And that trial judge's decision could be then considered an appeal. And that's how the law grows, right? That's why we have common law and the expansion of that. The rules provide the framework for that, but they're not necessarily the be all and end all of that. So I don't know. At some point, I think we need to be comfortable. It's better than where we were because we weren't anywhere. And I think it fairly represents the intent of what we're trying to accomplish. And if you view it from those standards, is there anything wrong with the language? That's my question to people. Comments, anyone? Well, good morning, Mr. Attorney General. I see your hand is up. Did you want to comment?
Thank you, Your Honor. Good morning. I'd like to respond to what you just said. And I spent 8 years as a prosecuting attorney trying cases. So I think I do know a little bit about the way the real world operates. I also served on the Commission on Rule and Practice of the Supreme Court for a good number of years and was one of the draftsmen of the revised Criminal Rule 16 that was really a result of, as several people here, Judge Salvaggio, how you doing, Tim? Nice to see you. You guys know we argued about that stuff for years and years and years over commas and prepositions and everything. I don't agree that good enough is the standard, candidly. I'd like to point out the consideration or considered by a court, considered at trial. What does it mean to consider? It means to listen to think about, and you might hold a ruling in abeyance, you might exclude it, you might admit, but a consideration is much broader than introduced. Introduced is, in fact, a bright line test, and it is much narrower objectively than being considered, even if we don't think about the direct object of that verb. I respectfully disagree. I think that this proposed change expands the language, it does not contract it. And that's my comment respectfully.
Well, thank you. I just, based on that comment, then you're comfortable or accepting of the not introduced at trial language? Is that what I take from your comments?
I'm saying that that's preferable to considered
thank you.
Trial.
All right, thank you.
The proposition has been advanced that this is somehow something that prosecutors would view favorably as a narrowing of the grounds, and I disagree with that.
Okay, thank you very much. Let's see, Mr. Young, you've not commented.
Thank you, Judge. I just want to follow up on the Attorney General's comments and Judge Salvaggio and Mark Godsey's, and I think they all come together. And that both of these have some gray areas. I think Judge Cost pointed out the problem with introduced is, was it proffered? Does that include that? And I, along those lines, the bright line test that Judge Salvaggio, user friendliness, I would suggest maybe neither of these are right, but Mark Godsey recommended a minute ago, part of the trial record. It's real clear. Did we talk about it or not? It's not whether it was admitted or not admitted. It's not, is it part of that trial record? Obviously including pretrial motions. I think probably captures and limits what we're trying to talk about. We don't then get into whether, and I agree with the Attorney General, considered is a little fuzzy at the edges. Introduced gives me problems about, was it proffered? Was it all those admitted issues, questions that get caught up in whether introduced is meaningful there. But that was all. Trial record, I think, might be a good compromise and suggest it. I think Mark Godsey should get credit for it, though. He brought it up first.
Tim, when you say trial record, what I'm trying to figure out how that scans. Admissible evidence, not
part of the record at trial.
Okay, not part of the record at trial. Mr. Attorney General, what do you think? Or
That certainly is at least more understandable. It's got better edges around it.
I would agree with that. Well, shall we just substitute then not considered? Or wait, no. What did you say, Tim, again? And Brian, can you? I want this. Can we
Not
put this
part
in?
of the trial record, I think is what I said.
Let's just add that for Brian, please, so everyone can see the language. Evidence not part of the trial record. Yeah, the one thing that we did note is, yeah, we need to re-add the word trial there, so it scans correctly. Which were to be considered at a new trial would
Judge Cost has some decent language also in the comment chat.
I'm sorry?
Judge Cost has some good language in the chat as well, a good point in there.
I'm looking for, I see Judge Costas, that's it.
I use the words proffered at trial or during any proceedings in the case. And then that seems to me that would cover any situation in which the evidence was brought to the court's attention for purposes of a direct appeal or post-conviction relief, as opposed to newly discovered.
Okay. People like that? It does clarify pretty succinctly. Tim or Mark, what do you think?
No, so proffered at trial or during any proceedings in the case. So one of the problems we wanted to avoid, one of the procedural bars that we wanted to avoid, which I think this would bring back in and engraft into the rule, is someone's been in prison for 20 years and you do DNA testing, and there's a fight in the court about whether it's enough to meet the standard or not. And the court looks at the DNA testing and says, yeah, it's somewhat exculpatory, but I don't think it meets the standard, so I'm going to deny it. Then 3 years later, the major witness recants. And you go back to court again and you say, well, now the major witness is recanted. And if a reasonable person sits and looks at the recanting witness with the DNA evidence, which got you most of the way there, but not all the way there 3 years earlier, an objective person looking at that holistically says, this clearly meets the standard. But when you do it that way, you say, well, the DNA evidence has been previously considered. So we have to look at the new recantation in a vacuum. And so if it takes a piece of evidence that's a 9 out of 10 on the level of strength, and you get something that's an 8, and so you lose, 3 years later, you get another piece that's an 8, and so you lose, each time you're not allowed to consider the powerful evidence that was before it. And so there needs to be, this is the problem that we've seen in a couple of courts where they force this piecemeal and then you can't look at the evidence holistically in an objective, fair way. And so that's why it needs to be at trial, so that if something else happens in the case, they can look holistically and say, looking at everything that's now happened after the conviction, does it meet the standard? And normal res judicata would apply. So if something's been, normal res judicata rules, but it shouldn't be made into the rule so that once something's considered in a vacuum, if something else develops in the case, it can't ever be considered again.
Judge Cost, was your proposal meant to include pretrial proceedings, rulings?
Well, yes, because what my thinking is that let's say that the defendant wanted to bring in certain evidence, like for instance, in a child abuse case, they say we want all the records of children's services in, and the court says no, you can't do that, and then the defendant doesn't protect the record and proffer those at trial. Well, that could have been directly appealed. It probably would be, if you're the Court of Appeals judge, probably be overruled because they didn't protect it at the trial record, as opposed to the pretrial ruling.
Mm-hmm.
But for purposes, and so then that would put it over to an ineffective assistance of counsel claim, either in direct appeal or in a post-conviction relief. But it's not newly discovered evidence, and I'm trying to figure out how to reconcile what Mr. Godsey's saying, because I certainly am not trying to prevent that. But on the other hand, what I'm trying to say is that I don't think that we want to create a rule where we give another appeal right on something that's been adjudicated or could have been adjudicated as res judicata. I think the comments he's making, I thought paragraph D, the changes there make some, give us that authority.
Right.
But even with the language as proposed of previously considered or not previously considered, I think, and I just don't feel comfortable with that. So what I'm trying to figure out is a way to draft something that says, if it was raised in the trial proceedings, then it's not newly discovered evidence.
So Tim Young suggested adding the word pretrial proceedings in the case. So that it would add to your suggested language, Rocky.
Sure.
Pretrial. So
I have no problem.
So it clearly references that the proceedings aren't post-disposition, but rather,
Can I ask if that solves Mark's problem? I just want to make sure he's okay with that.
Yeah, I understand.
Yeah, I think so. I think that's basically the same thing as saying not in the trial record.
Yeah.
I'm
We're
not,
just
I agree with
specifying
that.
any other proceedings don't mean anything after the trial.
Right.
That's not what we're considering. Okay.
Do we have a consensus on that? Can we just change that language and then move on? I mean, that's what it sounds like to me. So do I hear any? I don't hear any. It sounds like there's consensus then. So let's put in the language proffered at trial or during any pretrial proceedings in the case.
Judge Zamuda, while he's making that change, I did want to, if I could, respond to one of the comments you made on a related topic when you were speaking earlier, talking about the broad consensus for action and actual innocence claims. And that is the title of 33.1. But I think I'd be remiss if I didn't remind folks that there is nothing about actual innocence in the A, B, C, D, et cetera. It seems like a little bit of a misnomer for the 33.1 to be new trial based on claims of actual innocence, when that isn't a touchstone anywhere listed throughout here.
Okay, thank you.
Well, Gene, if I could just jump in, since Doug raised the issue, that was my secondary point. And I can't remember if we had talked about this earlier when John Martin and I were wrestling around with the idea of actual innocence, but as we know, actual innocence has a specific definition in 2953.21 A1CI. And so to the extent that there could be limitation of a judge's application of Rule 33.1 because the actual innocence isn't DNA related, it could cause us some problems.
I missed that last part. If it doesn't,
Well,
DNA
then,
related, the DNA related comment at the end, I missed, I don't know if it,
meaning that the actual innocence definition in the statute is DNA,
yes, under 29, 53.21.
yes.
Yes, okay,
And we can actually have, we all know we can have actual innocence based on using, I think, Mark's example, a recanting victim. So I'm just concerned that we may need to change the title or to Doug's point, well, what my concern is that actual innocence is defined in statute. So.
and that statute we will be considering once we vote on, hopefully vote on, Rule 33.1 language.
Yes.
I mean, that's the next part, that's where we go to next, if you look.
Secondary to that, though, I agree with Doug that the language of our rule doesn't really reflect colorable claims of actual innocence. My spirit.
I think one thing that could address that, Judge Samuda, is if the rule is entitled something like trial based on, new trial based on claims of newly presented or newly discovered evidence, or on additional evidence, whatever type of phrase it is. I think this is, like, the overbreadth concern is always there in terms of we're casting way too wide of a net. But I think that the title of the rule should at least be consistent with what the body of it is there. And this is more of a rule based upon new evidence or newly considered evidence rather than actual innocence.
Okay, anyone else? Is it the word actual or innocence or both that is problematic?
Both, because there's no touchstone to innocence or actual innocence, either as defined by statute or kind of the layperson colloquial definition in here.
Respectfully, I think innocence is actually there. I'm not going to fight with you about the word actual, but if it's a reasonable likelihood of acquittal, that's the definition of innocence.
No, the definition of innocence is you didn't commit the crime.
No, the definition of innocence is you weren't found guilty.
No, that's you're acquitted then, not that you're innocent, because we don't find people innocent, as you pointed out a number of times.
In our system, that's the definition. We don't have a third verdict like some countries do.
Presumption of innocence, though, we all know doesn't mean you're innocent.
Okay, so anyone else have a comment as it relates to the language?
Gene,
Yep.
maybe
Who is that,
one,
Steve?
it's Pierre.
Oh, Pierre, I'm sorry.
Maybe one way of threading the needle here is new trial based on claims of post-conviction evidence or something like that, because I do think that would be consistent with how the rule is structured.
New trial based on,
How about new evidence?
is it claims of new evidence? It's not a claim of new evidence, though.
Well, it's
That's why
evidence
you
that wasn't
said-
brought up to the court during the proceedings, so therefore it's new to the proceedings, even if it was perhaps discoverable before the proceedings.
Right. So Rocky, you're suggesting new trial based on new evidence?
Or something that gets that concept in. I agree that the title should be consistent with the language, and it is acquittal, which means, not proven, not guilty.
Right. So Rocky, I'm trying to see how that, I'm thinking for a word other than claim, though.
I mean, what about something that just tracks the standard new evidence that produces reasonable likelihood of acquittal? New claims based on new evidence that produces reasonable likelihood of acquittal.
I think it's long, but I think it's accurate.
Can you just say claims based on
new evidence
period?
that produces a reasonable likelihood of acquittal. which distinguishes it from the regular 33, which is just procedural stuff, like the jury talked outside when they did things they shouldn't have done.
Okay, put that in there, Brian, please. Claims based on, so strike of actual innocence. Mark, could you just repeat your language again?
Yeah, new trial based on new evidence that produces a reasonable likelihood of acquittal. And I think then you take out the on claim. So at the beginning, so it'd say new trial based on new evidence that produces a reasonable likelihood of acquittal.
Okay.
Are you leaving the word based?
Yeah, we have that.
Okay.
New trial based on new evidence that
Okay, yeah.
produces a reasonable likelihood of acquittal. Okay.
I would also just note that I put this in the chat that because we've changed it, yes, C1C has to be made consistent. Say proffered at trial or
proffered at trial, not introduced. That's correct. Yeah.
Or any pretrial proceeding.
Proffered at trial or any pretrial proceedings. All right, good. That's a good catch, Mark. All right. Any other comments as it relates to the current version of 33.1 that's before us by anyone? I don't see any hands being raised. Oh, wait, I got it too. Somebody in chat? No. Okay. Any other comments then before we move forward relative to this proposed language? John, did you raise your hand? John Martin, or were you just stretching?
I just scratched now. I raised my hand previously, but everything was taken care of by people far smarter than me, so I have nothing to say for a change.
Okay. Anyone else then?
Gene, it's Nick.
Yes, sir.
Going back to my question about what is patently frivolous, is there just an easier way to say which could be tested at hearing as to credibility?
Brian, can you move the draft up so people can see? Yes, thank you. All of C4.
I'm not looking to change the spirit of it, but I just don't know if there's an easier way or a more direct way to say what we mean.
What about saying it's patently frivolous if, even if the evidence is found to be credible, it would not satisfy the standard in A? I mean, because that takes a lot, that would take care of a lot of the ones that like our office rejects, because these people will come and they'll say, look, I've got this affidavit, and we look at it and we go, like, even if this person's found credible, that's not going to change the outcome of the trial. There's no reason the court should have to have a hearing in a situation like that. I don't know if that satisfies what you were.
I'm trying to understand, Nick, what you think. Yeah, what is it about? Is what you're proposing, what you've submitted, the offering you've submitted, can it be tested based on the standard that we've just set forth in a hearing or not? I don't know how else to clarify it than that.
I think my discomfort is with the phrase "which could be tested at a hearing." I mean, what does that exactly mean? Tested.
Oh, tested. Yes. Okay.
John has a suggestion.
John? Yeah, go ahead, John.
Would Judge, and if I can just, Judge Salvaggio, would it address your concerns if we said patently frivolous is defined as offering no new evidence, which, even if true, fails to satisfy the standard in section A.
I think it's perfect.
No judge has ever said that to me before.
We've recorded this, John, so you can, get a copy afterwards.
I mean, if that's what we're looking for, if that's what we mean, it's kind of, I mean.
Can we write the language down so people can see it and digest it a little bit? In which, John, you need to repeat yourself.
Your Honor, would you like me to add it to the chat?
Oh, if you just read it right now, we're adding it to the language, even if true.
Okay, so we would have the same language. Patently frivolous is defined as offering no new evidence, which, and then we would insert the following, comma, even if true, comma, would be the next word, satisfy, and then we would delete the phrase could be tested at a hearing to determine if it satisfies. And then that would link us back to the words the standard in section A.
Okay. Yeah, that's what we got.
Brian, did that make sense?
Yes, we got that, John. Thank you.
All right.
Doug, you had your hand up?
Yeah, thank you. So one of the things I think is, even if true, would not satisfy the standard in A. I think it's we want to make patently frivolous just things that don't satisfy that standard, unless I'm misunderstanding it. The other thing I was going to suggest, I put in the chat, patently frivolous should also include cumulative evidence as well as on material on collateral matters. So if it's not directly related to an element of the offense, it doesn't matter if it's new evidence because it's not going to change necessarily the outcome. So I think that those are two areas that would be important to qualify, that a petition could go out merely on the grounds of, yeah, this is a bunch of new stuff, but it's merely on collateral issues that might affect something else, or that it's cumulative to, we had 3 witnesses who already said it, now this is a 4th one. There's no real benefit to bringing that in, but I think those would be worthy to allow judges discretion to kick petitions on.
Gene, could I make a quick comment?
Sure.
So I really like the language that John suggests and that we include in here. And I think my reading of it is it captures Doug's concern, which is if you had new evidence on a totally collateral point, well, then that wouldn't satisfy the section in A, because that wouldn't show that you have a reasonably likelihood of acquittal. It would show that you proved that the light was red rather than green, but that doesn't matter in the context of your case. And I think the same thing with cumulative. If you just produced additional evidence that showed something that was already established at trial, or that you kind of substantiated at trial, I don't know that would certainly not satisfy the standard in subsection A. So I think both concepts are encapsulated in the language we have here in section 4.
Anyone concerned with the double negative, though? No new evidence which would not satisfy.
No, as it's written, there's no double negative. Respectfully, I think as Doug suggested it, I think he missed the first negative, and he was suggesting something that was doing the opposite of what he wanted to do. And so it's easy to do when we're doing this on the fly.
As offering no new evidence, which even if true, would not satisfy.
You got to take out the not.
Okay. Or the no.
Yeah, that's my fault. I added it when Doug mentioned it.
No problem. So Doug, do you see that? I mean, does that satisfy your concern, Doug? Is the question really? It's no new evidence, which would.
Yeah, he's correct. I missed the first no up top, I believe.
Okay. All right.
But I wanted to make sure it captured what his intent was, which is which I have no issues with that type of language there. I think it would be better to specify types of evidence so the judge can say this is merely cumulative, whatever. I think that up here was correct, that this is something that could be, judges could use this to screen out the types of complaints and types of frivolous actions that I was talking about. I'm just not sure that it's clear that they would.
Well, that would be left up to the discretion of the trial judge based on the ability of the attorneys to argue their respective positions in that particular case, which gets back to my point about the law growing, right? So you have a fighting chance, Doug, if you're in that court, is the point, as does Mark, you know, if he's on the other side. Mr. Godsey, you have your hand up. Do you want to add something?
No, sorry, Judge. I think it's been taken care of. And yeah, I think what Pierre said is right. You can't start trying to redraft the standard in A and 4. It's just going to confuse things. Kicking it back to A takes care of all those issues that Doug mentioned. If it's to a collateral matter or cumulative, then there's no way it's going to satisfy the standard in A. It's just going to start confusing things and trying to restate it in different ways.
Other comments then? I think we've gone through all the chat suggestions. I want to make sure we've addressed any other concerns that anyone else would like to raise at this time as it relates to this proposed language.
Judge, one area we skipped over was the criminal rules and civil rules in C2. I have some serious concerns about inclusion of civil rules of procedure here. This, I think I've mentioned this a couple times, and as it's come up over the last hearings, that the rules of civil procedure are far broader than what is under criminal procedure. And I'm not sure how appropriate it is to include those here in this proposal. This would be a very expansive type of discovery right that people would get with a very low showing of threshold. So you might be able to do depositions and interrogatory of prior counsel, judges, other things of that nature, just because it's not a patently frivolous claim. There's a whole lot of rights that are triggered here that I'm not sure we want to be inmates to be harassing folks with decades later, just because their claim isn't patently frivolous. I'm not aware of anywhere else outside of certain contexts, like in capital litigation, where there's such expansive discovery rights that inmates would be able to have access to.
Honor?
Yes.
John. And I appreciate the fact that, you know, we're all here not necessarily wearing our advocacy hats and instead trying to be objective rule makers. And so to that end, I appreciate Doug's comment, but part of me says it's really not fair to prosecutors in certain cases to give them that ability to depose the new witness who comes in with an affidavit. I in some ways, it seems to me that by expanding discovery, we're actually, you know, usually when we think about expanding discovery, we think about it in terms of it's helping the person who's opposing the action. And so to that end, my concern is that we might undercut the legitimate efforts of prosecutors if we took out that provision about civil procedure. And I would just voice that.
All right, thank you. Anyone else? Mr. Attorney General?
Yeah, and I recognize that I haven't been involved in some of the prior, so I say this with humility, but if I'm reading this correctly, I don't see anything in here that, at least in C2, which is what I'm looking at, maybe it's somewhere else, that suggests that the prosecutor has a right of discovery. It says the court may appoint counsel for an indigent movement, and the movement shall be entitled to invoke processes discovery. I want to echo Doug's concern here. The competing value in the justice system is finality of judgment. And I understand we're trying to create a safety valve for when the finality of judgment has overcome or in some way diminished the just outcome. And that's a good thing to do. And that's why we have the statute we have. But I'm struggling a little bit with the idea that after we've done this incredibly difficult thing of arriving at a final judgment and exhausted, it to a final appeal, that this supplementary procedure would then engage in much broader civil processes that were not available in the first instance. If we thought that the rules of civil procedure should govern criminal process, shouldn't they be available at the trial level where we're taking care of almost all determinations of a just outcome and having the presumption of finality of judgment? And we have made that policy decision as a society by the separation between criminal and civil rule procedure in virtually every jurisdiction that I'm aware of. It strikes me that we are, including or civil procedure, is literally upending the very delicate balance of competing virtues that we have worked out over many, many years. And with all respect to the very smart people on this call, I'm not sure that our collective wisdom outweighs the wisdom of hundreds of years of developing jurisprudence. Thank you.
Judge, this is Andy Wilson. Can I piggyback kind of on what the Attorney General just said? By creating this process, we're already going to interrupt the ability of victims to have some measure of closure, which is fine in these cases. Opening the discovery up to the rules of civil procedure, I think, creates a risk of subjecting those victims to even more potential damage than just the disruption in their ability to get closure. So I would piggyback kind of on what both the Attorney General and Doug have said up to this point.
So, okay. And then I think, Mark, you raised your hand again, correct? Mr. Godsey?
Yes.
Yes.
I would agree that we should, unless somebody can articulate the reason why, I would agree that we should take out civil procedure. It makes sense that criminal procedure would apply at that point, but that's extremely limited. I didn't write this section. I don't know who did, but I'm okay with, unless I'm missing something, I'm okay with taking out civil procedure. I understand what the Attorney General and Mr. Wilson have said.
Yeah. Well, it was again, this is the language comes from synthesized effort on my part with Brian, our help as we tried to put together what we thought had been previously discussed, and that there really hasn't been any objection or focused attention to this language. And if I recall correctly, and I'm just trying to rack my brain, I think it really pertained to the ability, as suggested by John, I believe, to give both the state and the movement the ability to test this new evidence using the civil procedure processes. Not so the fact that it says the movement only is problematic. If everyone is in accord that civil procedure really shouldn't be part of this process under 33.1, we can delete it, and then we don't have to worry about, because the other thing I think that should be probably, as I look at the language, we probably need to clarify that it would be the trial court that trial court has to control not only the appointment, but the extent to which additional discovery processes would be warranted in that particular case. So anyway, Tim? I think you had your hand up.
I just wanted to also confirm, we didn't have civil procedure in there and we don't object to it coming out.
Well, if there's, John?
Yeah, I'm fine with taking out civil procedure, but if I could address the other concern that was raised by the general, if we invoke the process of discovery under Ohio rules of criminal procedure, part and parcel of those rules is a reciprocal discovery responsibility. So it's not as if the criminal rules in and of themselves, saying that we invoke the rules of criminal procedure doesn't mean that the state gets, that the prosecution gets nothing. So I'm fine with taking out civil procedure, but I don't think that we have a concern that the Ohio rules of criminal procedure that is a one-sided term simply because it refers to the movement, because if the movement avails him or herself of that, the reciprocal discovery responsibilities will kick in anyway.
Yeah, I think Doug's suggestion, which movement probably should be changed to the parties. So I think that helps resolve that issue if we make it clear that the party shall be entitled. Agreed?
Yeah, take out or civil procedure.
And then take out or civil procedure, Brian, please. Thank you. Yeah.
The elsewhere in the usages and principles of law is incredibly vague as well. So I don't know any benefit of including that other than to invite inconsistency and unpredictability.
Everyone comfortable in leaving it under the Ohio rules of criminal and ended at procedure?
Yeah.
Yes. Delete it, please. Okay, great. Then you need to put it. Oh, yeah, okay, we got it. All right. Other concerns? Comments? Mr. Attorney General? I think you raised your hand again.
Yes, thank you. I'm wondering if there's been any prior discussion on C3 about a time frame. It occurs to me that without casting aspersions on one side or the other, virtually every piece of litigation I've been involved with has had at least one party who had some interest in prolonging matters. I wonder, we're creating a time frame once discovery is concluded, and since that's in the hands of the parties, I wonder if, I don't really have a suggestion. I'm just wondering if there's been any discussion about the open-ended nature of that time frame and whether it might be subject to abuse.
So Mr. Attorney, I can tell you that language was created in an effort to address a too common practice by some task force members, that there are some trial court judges that just sit on these motions for a long period of time. And I think there was a case out of Cuyahoga County where the trial court took 1.5 years or longer, if I'm not mistaken, to just rule and didn't do anything, didn't schedule a hearing. It just sat there. And rather than try to constrain, and you'll see if you've looked at some of the proposed changes in 295321, we try to address putting in some time elements for a court to rule. I think this wasn't an effort to recognize that, look, you can't just have the matter languishing once discovery is concluded. And I do think the trial court must manage the discovery just like they do in all litigation. All right, so it's up to the trial court to determine how long discovery is reasonable, and they should maintain that based on their current practices. But once discovery is concluded, set the matter for hearing and then reach a conclusion. I think that's all that's meant for this, which is why it's phrased the way it is. Anyone else?
Judge,
Comment.
we close out real quick on 33.1. I did want to echo kind of a final time with the language of D is kind of new to this draft here. It's been tweaked from the last time. And it's a comment kind of that in conjunction with B, with the kind of the compromise of idea of taking a time limit off for these types of motions at any time in the future. That does seem like a reasonable compromise because, as you know, Tim Young and I agreed at other hearings, there shouldn't be a time limit on if you're actually innocent of a crime. You know, there's never an interest in holding that person in prison later. However, the D lets us bring, or lets movements bring a wide variety of different types of post-conviction attacks on their Brady violations, and specifically anything that undermines the state's theory of guilt. And I'm not sure there's quite the same kind of moral imperative to allow people to file those types of motions forever. It really cuts against any type of finality of judgment. And so I think that that's a concern that while the timing issue might have been a good compromise when we're looking at under B, might have been a good compromise when we're looking at actual innocence. Given that there's such a broad array of claims here, it seems I think a lot of people are going to be uncomfortable with the idea of being able to bring such a broad type of action for forever on these types of claims, especially when read in conjunction with some of the proposed edits from OPD on the statutory changes, where it would allow successive petitions. It's very concerning that there is no time limit, and then that these can be done without pertaining to actual innocence.
All right, thank you, Doug. And I know Mark first and then John. Scottsy.
If it would make it clearer, we could have D refer back. I mean, I think it's implicit that's referring to only evidence in this category that satisfies the standard of A. So it's not going to be frivolous stuff. It's going to have to be a Brady violation that you look at and you go, wow, this person probably would have been acquitted had this been disclosed. So we could make the explicit reference back to A if that makes it clearer. I mean, I think it's implicit, but we can make it explicit.
I didn't think it's a lack of clarity. I don't think it's necessarily unclear. I just think it's a overbreadth issue, not a lack of clarity issue.
Well, you probably really want to say under this rule, not this section, because this section is subsection B, right? You really want to say under this rule, right? Under 33.1, which then ties in the standard of A, right?
Right, Gene, I think that makes sense. And I think it addresses the concern that this is a proliferation of the types of claims. I mean, my view of it is this is a claim, and these are the types of supporting evidence that can be brought to pursue such a claim.
So do we want to substitute rule for section? Mark, yes. Doug, I mean,
that makes sense to me.
Yeah, that makes sense.
I believe the word rule, then capital R, please. Anything else? Any other comment? Oh, John, I'm sorry.
Yeah, I just, Doug, help me understand which one of the items listed in D is causing you a problem. I mean, when you're saying that this has become overly broad, which one is it that you would take out?
I would the evidence that undermines guilt. I guess this is in conjunction when read in conjunction with A, because like I said, this is, you know, if we're expanding this rule beyond actual innocence, I think it captures what you guys are intending to do, and I understand that. I just think that it captures casts a far wider breadth than someone like myself would be comfortable with. That's what I was getting at. I think that the things that you listed there are all types of things that we understand that are all ways that could undermine guilt and could be used to attack a conviction afterwards. That's not my concern. It's more of the mission creep, I should say, to turn this into a wholesale second guessing of convictions after the fact in perpetuity. That's where I'm concerned about is removing that. This is this is going to be a lot of work for trial courts, and I'm not sure that we're necessarily appreciating how many resources are going to have to be dedicated to this after the fact, and the types of resources that's going to take away from, because the same people who are doing this are the ones who are trying the cases on the front end. The more resources we dedicate on the back end here without allocating more to local governments is going to jeopardize justice on the front end. So I just think that that's the bigger this funnel is here, the more it's going to impact other aspects of the system, despite best intentions.
So you think D actually expands beyond where your concerns raised about the scope as articulated in A? Is that what you're suggesting, Doug? Is, if I take that, I'm just trying to understand exactly what you're saying. Or this just merely articulates the types of evidence that helps explain why you have a concern about it going beyond your view of actual innocence.
Yeah, I would just say it amplifies the concerns. They're not separate concerns from what was identified in A. If that's what I think you're correct. That's correct. Yeah.
Okay. Thank you. Did somebody else have their hand up? I think. Oh, Nick, you did. Yes, Judge Savaggio.
To Doug's point, might I suggest that the phrase in the first line of D, but not limited to, is redundant with the last sentence, which says, or any other evidence that undermines theory of guilt or that directly contradicts evidence used to convict the defendant. I mean, it just seems to me that but are not limited to better and more accurately captures the spirit of what we're trying to do, whereas the last line of any other evidence is so broad and expansive that we start to get into maybe some other areas that this rule is not intended to encompass. And so I would offer to the group that we strike the last or, and because it's taken care of, but are not limited to.
Types of evidence to be considered in this rule include but are not limited to. Oh, because it says but are not limited to. So Brian, can you scroll down so that everyone can see on the shared screen the specific language that Judge Savaggio is referring to? There you go. Thank you.
I personally don't have a problem with taking out just what Judge Savaggio just said.
It is redundant. So we would end subsection D after the parenthetical of 1963.
Yeah.
Okay. Anyone else? Hearing none, is there then, what's the wish of the task force as it relates to comfortable in a motion to recommend consideration of this? John, did you raise your hand?
Yes, I would move to that the task force include a recommendation that Rule 33.1 as drafted presently before us be approved by the task force as being recommended for inclusion in the rules of criminal procedure.
Thank you. Is there a second?
A second.
Second.
I need a name. I'm sorry.
Tim.
Tim Young. Okay. Thank you. Tim Young seconds. Any discussion?
Judge, this is Andy Wilson, and I know there's been a motion in a second. My only point would be, for an hour and 15 minutes, we've been discussing, debating, and amending this document. It certainly isn't the document that we started with this morning or had the opportunity to review before this morning. I don't think there's any harm in getting a clean copy out to everybody, allowing us to just kind of review what is cleaned up, what's actually in writing, digest it, and then setting this vote actually as a vote only, no more discussion, just as a vote only at the beginning of the next meeting. So I'd just throw that out there for consideration.
All right, thank you, Andy. Comments from anyone else with respect to Mr. Wilson's suggestion? Mr. Attorney General, did you have your hand up as it relates to that issue, or did you want to comment relative to the rule itself?
I have another issue to raise.
We'll deal with that issue after we deal with whether or not we're going to vote now, or does it pertain to that? Mr. Attorney General, I'm not sure. Your other issue, does it pertain to or impact if we decide to vote now or not?
No.
Okay. Any objection to, it doesn't matter to me. We have been vetting this particular issue, 33.1, for a couple of months now. I think 3 successive meetings. So, and we have each time, and I had hoped that by creating the synthesized rule that we would be able to vote on it. Okay. But if people want the opportunity, the other thing we can do, and I've done this before, especially with Zoom technology, is to indicate that we will send out a draft and you vote to us electronically. Although I think, Brian, we can't do that, can we? I think the way the rules of the task force work, we have to be in session and vote. So we either vote now or we vote at the beginning, vote only at the next call, which our next meeting is scheduled for May 21. Everybody comfortable voting now? Whatever the consensus is, it matters not to me.
Well, let me, Mr. Chairman, if I might raise my other issue, it may impact Mr. Wilson's desire to prolong this, because
Okay.
I intend to vote no, whether it's today or next week. And I would like to explain why. This rule is in significant tension at best with the statutory substantive rights that are granted by the General Assembly. A rule of procedure is definitionally a rule of procedure. And when I was on the Commission on Rules and Practice, we regularly talked about whether a thing was procedural or substantive, and whether it conflicted with the substantive provisions. I have asked my staff to do a review, and while I don't have a formal legal opinion that I can distribute, and it might not be welcome even if I did have one, suffice it to say that I've got substantial concerns that this rule is beyond the authority of the court to adopt. And I would request and intend after whenever the vote occurs, I intend to make a motion anticipating that my negative view will not be the prevailing view on this committee, that the draft be referred not to the Supreme Court, but to the Commission on Rules and Practice for consideration of the issues that I'm raising about conflict with and potentially expansion of substantive rights that must be undertaken not by the court but by the legislature. So, Andy, given that outline, does that affect your position at all on whether we should vote today?
Attorney General, not necessarily. You know, I like what the judge said at the beginning. You know, right now we have nothing with respect to this issue and claims of actual innocence, and you know we're moving towards creating something. When I looked at the document in preparation for this meeting, I didn't think that we had something that I would be willing to vote on yet. Although I do appreciate the concept and the need to do something in this space. But we've made a lot of changes today that I believe have moved the needle. I would just like to see a cleaned up document and look at the changes that we've made today in a clean document. I don't think we need to discuss it anymore, but you know, we could vote early on the next meeting. That's where I'm at. I can vote either way. I just, I think we made some pretty substantial changes that address some of the issues that I had coming into today's meeting. I just would like a second to take a look at those and consider them. So, I can vote either way.
Well, if
Yeah,
you're,
Mr. Attorney General, can I ask you a question, please? Do you anticipate having that memorandum or the opinion, I'm not sure what, from your staff, completed and available for the task force to consider? Because we would welcome that, quite frankly, prior to May 21?
Your Honor, I perhaps misspoke. I did not ask them to produce that. I was defining what I was offering and limits of my knowledge, and not suggesting that I had tasked them with that. I certainly would be willing to do that if you felt it would be helpful. Well, actually, I got to think about that. I would need to think about what my potential and duties would be if there could be subsequent challenge litigation on this. I might have a duty to defend, so I'm going to demur at the moment, Your Honor. I hadn't thought through all of that, but
okay. I appreciate that. Thank you. And as chair, I'm going to ask that we. I'm not going to ask. I'm going to. Did somebody just raise their hand?
No. That's all right. Go ahead, Your Honor.
All right. Thank you. It's my intent. I think the prospect, as articulated by the Attorney General, should give each of us some additional things to digest in the context of making sure that they're comfortable in whatever your vote will be as it relates to this language. So taking that in conjunction with Andy's sort of practical sense of, let's make sure that the wordsmithing that was done today really makes sense, and it satisfies my comfort level in whatever vote we're asking you to make. We'll vote on this first order of business, May 21, our next scheduled meeting date. All we'll do is we'll call the proposed language and enter a vote, so we won't be taking more time wordsmithing that as well. All right. So that's and I think as chair, I have that prerogative to do that, and I'm doing that at this time. All right.
Thank you.
Thank you. Thank you all very much for your hard work on that. All right. So moving then on to discussions of post-conviction relief petition 2953.21 and criminal rule 32. So we did receive proposed language suggestions from Joanna and the Ohio Public Defender's Office. Can we pull those up now? Because I would like to, it's 11:25. I would like to begin that discussion since we have a little bit of time before our noon hour. Hopefully you have each seen this language. So the only proposed language we've seen has been submitted to us by OPD, excuse me, sorry, Tim. I don't know, Tim, did you want to walk through your proposed changes? Or do you want Joanna to? I'm not sure. Joanna?
I'm sorry, I was going to ask Joanna to lead us through them. She was led the drafting committee.
I'm happy to. So just generally speaking.
I'm sorry, Joanna, before you start, Brian, could you expand this so that we can see a little bit better? I'm having trouble seeing it on the screen.
If you look up at view options on the right-hand side of the floating bar and pull that down, you have the ability to do a custom zoom for yourself.
Okay, great. Thank you.
Oh, I didn't know that. Thank you.
So our sort of general concerns is what we find is that many defendants don't know about the availability of the post-conviction remedy, especially non-capital defendants who don't have counsel. And by the time they learn of that, after their direct appeal has run, the time to file a timely post-conviction petition has also run. And then there's additional difficulties in procuring the evidence necessary to support a petition of this nature without having counsel or access to evidence. And so we attempted to address those. Just off the bat, one of the big changes we made was taking the language from 2953.23, the time limits, and incorporating that into 2953.21 so that everything was together and didn't have to be cross-referenced. I think going through the rule, the sort of first thing we get to is in 2953.21 is section E, which takes the right to discovery that's been added in for capital petitioners and extends that to non-capital petitioner as well. So, I mean, we didn't change any sort of the substance of that. We just made it applicable to everyone.
Okay.
And then I can keep going. Moving on to section 2A, this is where we incorporated the language from 2953.23 into this rule. I think subsections C, 3, and 4 are pretty similar to what is already in the rule. The changes are to 1 and 2, and we tried to harmonize that with the language that's commonly used in federal habeas proceedings. What we found is that it's under 2953.23, it's near impossible for somebody who has new evidence to satisfy the current standard. And so this opens it up a little bit in the sense that it acknowledges that there are many reasons why somebody might not have had the evidence previously, including failures on the part of their counsel. And so that would be encompassed in that cause and prejudice language and would permit someone to file a second or successive petition where there's been a failure of counsel. And then part 2 mirrors some of the manifest injustice language that we see in habeas proceedings. And then.
So that's 2C and all of its subparts. That's what that attempts to.
Yes, 2C and then subparts 1 through 4. But 3 and 4 are pretty much the same as what we currently have, with subsection 2C3 having the addition of a new recognized right by the Ohio Supreme Court, adding that in. And then the other change we made, which mirrors some language in what we've added to Rule 32, is in section, let me make sure I have this right, J4, is adding in provisions that would permit courts to appoint counsel where a defendant has claims that have arguable merit, which we've defined there.
Okay, let me intercede, just because I think let's go back. I think it might be easier to do it the other way, which is address them in sections as pertain to the various sections of the statute, so that we can see what kind of impact or input or consensus or objections there may lie. So let's go back to the discovery. So Brian, we want to go back up, and Joanna, let's just the changes are, although they appear minor because you're striking just one clause, the effect of that is to expand greatly the discovery sections to apply now to all post-conviction petition cases, correct?
Yes, so to make discovery available to all post-conviction petitioners.
Okay. Judge Salvaggio, you have your hand up.
I do.
And then Doug, and then Mr. DeMotte would be next. So go ahead.
I'm not opposed to expanding this to life sentence cases, but I would be opposed to expanding it to all cases.
Anything more than that? Is there the distinction? Why you would distinguish it and say if it's a life case or death case, it's applicable, but not for a felonious assault?
Yeah, I had tried to, but didn't have the time to go back to the creation of the statute to find why in the first place they had limited it to capital cases. I don't know that I can articulate concisely the reason, but I'm willing to acknowledge that whenever somebody has a life sentence or an indefinite sentence that includes a life sentence, that there should be opportunities.
Okay. Mr. Demuth, Doug?
Thank you. So I guess as a preliminary matter, I think I went through all this, and I'll go through them as we go through. But my suggestion would be, rather than trying to get any type of consensus on almost any of these points from the group, I mean, this seems like something that OPD, OIP should probably pursue through the legislative process. I mean, they have a very active legislative wing, and I'm sure that they can find some support for this. And I don't necessarily think it's a going to be a meaningful use here to make a recommendation to the legislature of, here are some things you can do, because I think that there's not going to be a whole lot of consensus. But moving aside from that, just the general kind of concern about this legislative endeavor here, I would say that OPD and OIP, to their credit, have been extremely successful over the years advocating and explaining why death is different. And now this is asking us to say, no, death isn't different. Everybody should get the same type, that full panoply of rights that that our post-conviction statute sets forth for individuals who have been sentenced to death. I mean, everyone on this call knows how resource intensive death penalty cases and how protracted death with penalty litigation is. And I think that this is going to open the floodgates of that type of resource intensive work to every type of conviction. And I honestly have a lot of concerns about even doing it for life sentences, because once again, there is a finality, let's say, of judgment in a death penalty case when the sentence is in fact carried out. Life sentences have no such finality, and this is going to be an open-ended right forever for to attack life sentences and litigate these issues ad infinitum. So I just don't think that this is something that makes a lot of sense for public policy reasons, as well as a host of other practical reasons for the people who are going to have to be practitioners in the system in a world where we do have limited resources.
All right, thank you, Mr. Demuth. Joanna, did you have your hand up again, Joanna?
I did. I mean, I think death is different, but I think innocence is also different. And I mean, we're not suggesting that every right that's afforded to capital petitioners is given to everyone, but the situation we currently have is that once you're convicted as a defendant, you have limited rights to public records, limited rights to discovery, yet somehow you're supposed to find all this evidence. And, you know, when we look at the National Registry, we know that more than 50% of exonerations or wrongful convictions, rather, are the result of prosecutorial misconduct, with a large amount of those being Brady claims. And so I think if we want to meaningfully address wrongful convictions, that we have to give defendants and petitioners some ability to get at that evidence. And this is a step toward that.
Representative Leland.
Yeah, I mean, I'm listening to the debate, and it's amazing how smart everybody is on this call. When it comes to public policy issues, though, I think that, you know, this is my 5th term in the Ohio General Assembly. I think it's important to bring these issues up and let people discuss them. And I don't know that anybody's got the right answer, but I think the process is that these things are proposed. We hear testimony, and people who are elected, not just all of us, but people who are elected to make public policy decisions will make the decision as to whether or not resources should be allocated to this type of activity or not. And that's what the process is. So I don't see any problem in making these proposals and then see how they work themselves out through the process.
All right, thank you. I just want to make sure everyone understands that the task force was created by the chief to look at wrongful convictions, certainly, but as I've probably said to each of you more than you care to hear, post-conviction practice as well. And I guess as I'm listening to the testimony, and I mean the discussions just now, the question that pops into my head that I would ask Joanna is the extent to which you're framing these potential changes. Are they impacted at all by whether or not whatever happens to 33.1? In other words, if you presume 33.1, let's just say it's going to somehow become part of the criminal rules down, however that, well, we know how that happens, but would that impact these? Because I think we need to look at it, or are these separate, as I view it, are there problems with the post-conviction practice that go beyond just wrongful conviction processes, if that makes sense?
Sure. So, I mean, I think there's an overlap in the claims that would be raised under Rule 33.1 and the statute, but not entirely. I think as we drafted this, we envisioned sort of looking at each in isolation and making the improvements that we thought were necessary, with the idea that we wouldn't know whether 33.1 would be adopted. But generally speaking, I do think there needs to be changes to post-conviction practice. As I mentioned, people just don't know it exists. They don't know that they don't have the right to counsel. They don't have access to evidence. And I think that outside of whether 33.1 gets adopted or not, those changes need to be addressed.
All right, thank you. So any other comments as it relates to this formatting proposal, which is to eliminate the limitation of the discovery components of post-conviction to death penalty cases? Anyone?
Your Honor.
Yes. David, yes. I mean, John, sorry.
And if this is the wrong time to say this, then just cut me off right away. But as far as this issue about whether or not we should be considering this vis-a-vis other folks going, or part of us going directly to the legislature, just to echo what Judge Zamuda said, I'm looking at our mandate from the Chief Justice. 1.02A is pretty darn clear that we shall offer recommendations concerning necessary revisions to current legislation and rules. I think that if we were to say that we're going to ignore a statutory change in this situation, we have an explanation to give to the chief as to why we didn't do what she told us to do.
Okay, thank you. Any other comments then as it relates to this proposed change? I just want to make sure that we've had adequate time to discuss it from participants. If there's anyone else. All right, let's then go on to the next category, which is the 2C. I think you're attempting to incorporate federal habeas processes. Yeah, right there.
Sure. So, like I said, this was an attempt to clarify when a petitioner can bring a second or successive filing, and to cover situations where they may have been prevented from discovering evidence because it was either suppressed by the state, which would be the cause and prejudice, or they had ineffective assistance of counsel at any stage in the proceeding who failed to discover that evidence. And so where they have good reason and they're prejudiced by the failure to get that evidence in a timely fashion, they'd have the ability to still file a petition.
So does this language track precisely the language under the federal statute?
Well, in the federal case law, the cause and prejudice standard is utilized, yes.
Okay. Judge Salvaggio?
So a comment and a question. The comment was with regard to 2B, 3i. Doesn't that go without saying? In other words, if the Supreme Court or the Ohio Supreme Court has recognized a new right, I mean, wouldn't that automatically open the right for a petition? But number two, the question I had was with the use of the phrase actual innocence, was that intended to mean something different, Joanna, than the definition of actual innocence under A1 C little I? above?
So in section 4, I took that language exactly from what's in the current statute and didn't change it at all. And I think Mark might have stepped out, but as far as with respect to DNA testing, I would let Mark, I'd defer to Mark on that.
Okay.
All right. Brian, can you go up? Can you pull it up a little bit? Because it starts with, yeah, all right. Go up to beginning of this subsection though. A little bit more. It's 2, there you go. Okay. Any other comments as it relates? Oh, Doug, I'm sorry, Mr. Demuth, you had your hand up. I'm sorry about that.
No problem. No, I do enough talking. You're fine. No, so I guess my concerns on this one would be is using I think it's not a good idea to look towards federal habeas law as a kind of the touchstone for what we want to do here. If that process worked and worked well, we wouldn't necessarily be here. If there was a valid, good way of challenging convictions and kind of through the process that way. The other problem there is our office spends time endlessly litigating these petitions year after year after year. And no one in their right mind necessarily that I can think of would want to recreate that system under state law. And so there are a lot of things that we can look to in federal law, but I'm not sure that the kind of their habeas standards, practices, and procedures are something that's worthwhile to be emulated. The other thing I'd mention just in terms of what we've talked about right here is this seems to eliminate any meaningful deadlines in terms of filing an initial petition and successive petitions on even potentially the same topics, because the court always has discretion to grant it. So when, if there's a manifest injustice, that's in the eye of the beholder here. So I think this is one of those kind of things where the change might seem somewhat minor, but this effectively eliminates time restraints and prohibitions on multiple successive petitions, kind of the res judicata bar on petitions for post-conviction relief, unless I'm missing something.
Anyone else? No? Let's okay, let's take the next section then. It still pertains, I think, to, yeah. Subsection F, you're adding the standard like most favorable to the petitioner.
Yeah.
Joanne, wait, go back, Brian. I think that I just want to make sure that we give you an opportunity to present sort of the background of the thought process as to these proposed amendments.
Mm-hmm. Okay. So section C, I think, just relates back to the discovery.
Right.
And section D requires findings of fact and conclusions of law in all cases. As to section F, we added in the viewed in light and most favorable petitioner because right now hearings are so infrequently granted. And we're in a situation where petitioners, at least at present, don't have counsel, don't have rights to discovery. And then if they are denied access to a hearing, they're really given no opportunity to develop the facts. And so where they present claims that viewed in the light most favorable to them show that they may be entitled to relief, we wanted to ensure that they were able to get a hearing.
Okay, thank you. Comments? Mr. Demuth?
Yeah, just briefly on that one. It's kind of like the reverse Bridgman standard there for movements in these kind of cases. And what I would probably say is hearings are granted very rarely for good reason on these things. There should be some confidence that, generally speaking, the system gets it right, and generally speaking, the convictions are valid. And so it should be the exceptional case that gets a hearing on these, not just everyone that viewed in a, light most favorable, the petitioner gets it. There should be they should have a fair option to have these litigated and an opportunity to raise the issues. But I don't think the thumb should be put on the scale either way when the court's reviewing the petition. If there looks like there are substantive grounds for relief and there's a good, reasonable chance that they might be granted relief, sure, absolutely. And I think that's how most judges, most trial judges evaluate these. But they need to be able to sort through, frankly, the BS ones that they know aren't going to go anywhere.
All right, thank you. Joanna?
I think the intention of F was already to sort of view it in the light most favorable to the petitioner, in the sense that, it's viewing it whether what they're filing shows they're not entitled to relief. That's what we already have. And I think this just clarifies it. If it's a BS petition, as Doug said, even viewed in the light most favorable to them, it won't pass through. So, and I agree we should be assuming that our system gets it right, but I think the whole purpose of this task force is the acknowledgement that sometimes it doesn't. And so these changes are meant to address those circumstances.
Do you believe the inclusion of the additional language changes the standard by which a trial court can rule? Or do you think it incorporates what standard trial courts should be utilizing?
I think it just incorporates and clarifies. The way I read that is that it was sort of intended to be something that was viewed a little more favorably to the petitioner, and this just clarifies that.
Okay. Anyone else at this point as it relates to what we have before us? If not, let's move on to the next section, please, which I think is I. Oh, no, it's G, I'm sorry.
So this just gives, non-capital petitioners the ability to amend where they find additional evidence that would support their petition.
Okay. Import of this is to the expansion beyond death penalty case.
Yes. Okay. And then H also addresses findings of fact and conclusions of law. So I think J is the next significant change.
Well, A requires the findings of fact for all petitions, not just on sentence to death cases.
Correct.
Yeah, okay. Well, you do have, J, yes, here we go. All right, go ahead.
So for J, we just wanted to create a mechanism for counsel to be appointed to non-capital petitioners. So we set forth an arguable merit standard where a petitioner or counsel could file a motion to be appointed. And the standard is there in J4.2 that we're proposing. And then corresponding, we put in Rule 32, the requirement that a sentencing judge notify a defendant of the post-conviction relief statute, and that they may file a motion to have counsel appointed under J4.
Okay. Anything else that relates to J before I?
No.
Okay. Mr. DeMuth, I know you had your hand up, and Judge Savage.
Before I I'll let Judge Savage make comments first, but my question was, can you explain a little bit more the impetus behind why you want those motions to be filed ex parte before, and then I'll put my hand down for a moment so other questions can be asked, then respond.
Oh, I think, if you have to explain sort of the merit of your claims in order to have counsel appointed at a stage when they're not fully developed, it just gives defense the mechanism to not share everything they've already developed prematurely with the other side.
All right. Nick?
Joanna, I don't remember if it was last time we were together or the time before that. We had discussion as a task force about whether a judge should try to drive some of these cases to the public defender's office or the Innocence Project. How do you believe or anticipate a court appointing counsel for post-conviction would impact the task force's hesitancy in not designating specific agency or specific groups. I mean, is it the desire that a certain counsel with certain qualifications be appointed, or how would a judge make that appointment?
Sure. So I think we had suggested some changes to the Ohio Administrative Code as well, and I'm not positive that those were distributed, but that fleshed out the requirements in order for a person to be appointed to take on a post-conviction petition. And so I think that we'd heighten the standards and like the CLE requirements for that body of attorneys. And certainly like the Ohio Innocence Project and the Wrongful Conviction Project attorneys would likely be on that list, but there'd be private practitioners or other counsel who would have those qualifications to take on this work as well.
If I may, Judge, we don't have the capacity. We simply don't have the staffing or the capacity to review these cases. And if a statute or a rule was written that they should be referred to OIP or OPD for first evaluation, ultimately we're going to end up in a staffing fiasco. Just so you're aware, we're in the middle of staffing problems today. We're below our staffing levels from the year 2000 today. Mm-hmm. So we simply don't have that capacity. So the reality is, and being unable to anticipate being able to fill that capacity, what we did, and the Public Defender Commission, the 9 people who oversee the system in Ohio, have rulemaking authority, and we've recommended to them to pass requirements for training on post-conviction. That would be part and parcel of, they would have to meet that to be appointed.
And thank you, Tim. And I accept what you're saying. And I think it goes back, though, to a point I had made earlier, which is I think some lawyers need to have specialized expertise in these areas. And I accept Joanna's statement that through the OAC, we would promulgate some of the standards that are needed to accept these cases. But I think this just reinforces my point when we had discussions about Rule 33.1, that there needs to be some measure of expertise that is managing the issues that are being raised by the offender.
As a point of order, Judge Savaggio, the way the task force is developing and designed is those subjects, if you remember from a long time ago, the educational process and the training, those issues will be dealt with once we get through the substantive law changes. So once we complete post-conviction, which is why the OAC recommendations that OPD has submitted to us weren't part of this, because we're not addressing that presently. I'm not sure if your concern is, I don't know that I can support the general concept that there should be a easier method of having or allowing the appointment of counsel on these post-conviction cases. That general concept, that can be separate from, if so, then how do we compensate them, and should there be specialized training as it relates to them? That's your questions are focusing on the latter, not necessarily the concept that, yes, they should have the right of appointed counsel. And then once we make that decision, how are we going to effectuate it?
No, I mean, some of this dovetails into, I think, and I don't want to steal Joanna's thunder, but then subsection K, which is the judge that presided over the trial shall not rule on the petition. And the concept of, well, in a single judge county, you have the judge appointing the lawyer and you have the judge ruling on the petition. And it will be the same judge who presided over the trial. I mean, as it stands, unless we change it. And my issue isn't, well, how do we qualify these people, these folks? It's the fact that we as a task force recognize that the person that is going to represent the offender is going to have specialized expertise.
I think we'll reach that, but we're at the point we're saying that we believe the system should be created and allow for the appointment of counsel, and making that commitment as a system, we then must assure that the person who would be appointed is qualified to competently represent that petitioner in one of these proceedings. I agree with that.
Okay.
Okay. So, but at this point, we're I think vetting the efficacy of the appointment of counsel on these petitions in and of itself. And then that decision will, we'll have to vet the consequence of that going forward. All right. Anyone else then yes.
Yeah, this is Steve McIntosh.
Judge McIntosh. Okay. Yeah, sir.
Yeah. No, if I could just ask a question of Joanna, and I know we touched on this a little bit last time when we were looking at the rule, but in paragraph K, I mean, is it just automatic that the petitioner requests a different judge and then a different judge would be appointed? Or is there some certain standard or something that would have to be established as to why the judge that handled the trial should not be permitted to deal with the post-conviction matters as well?
The way, we discussed it at OPD was that there wouldn't be a standard written into K. I think certainly we're open to discussing what that might look like. But we wanted to start from this position. We've seen in cases, we did a study of all the wrongful convictions we've had in Ohio, which is about 85. And we see that in the vast majority of them, it's unlikely to get relief in the trial court. And we thought that this might be one way to address that and prevent what usually turns into 8 to 10 years of litigation, and hopefully catch these wrongful convictions at the earliest stage.
Just another follow-up question real quick. I get multiple post-conviction motions from the same defendant. So every time that defendant would file one, could they then request a different judge? So, I mean, the person that I have that has filed 10 prior motions could potentially get 10 different judges to rule on those motions?
I can clarify the language, but our thought was just to make it so they wouldn't necessarily have the trial judge. I don't think they can just kind of keep shopping around for the judge that gives them what they want. So I would envision it as one change, obviously subject to recusal and disqualification in separate proceedings, but under this, just that one change.
Okay, all right. Thank you, Joanna.
Joanna, this language in K is similar to, or I should say there was similar language in an earlier draft of 33.1, which before we did the consensus rule, I think everyone agreed should be removed for reasons that Judge Salvaggio raised then and has re-raised here. And Judge McIntosh also raised similar concerns, because there currently is a mechanism for removing if the suggestion is a trial judge that heard the trial somehow is predisposed in not to do his or her elected responsibility in vetting that petition appropriately, there's a mechanism to remove that judge, which is exercised on a regular or frequent basis, given the volume of affidavits of prejudice that go before the chief. So why you're creating this, and then the other category that struck me as an appellate judge, I guess, is, does this create an even broader concern that on every remand, if an appellate court reverses the trial court's decision, that the trial court can't sit to rehear that trial? Because is it really any different?
So I think the reason we started drafting this well before the last meeting, but also I know that a number of members weren't there. And so we kept this in because we thought it was worth continuing the discussion and made some changes because I know last time part of the discussion was more on the procedural end of it, on how we would actually accomplish this. And so we tried to adjust for that. I'm going to put him on the spot and kick it to Tim. Because I know we discussed this at length in our sort of subgroup meetings, and Tim had some thoughts.
We included it, honestly, she's right. We included it. We knew it would be a point of discussion, but we wanted to continue the conversation.
Okay.
And I think it was especially honestly ripe in our office, given the recent case that we've been working on out of Cleveland. This is a very raw issue for us. So perhaps that was also some of our influence in including it, but it is worth discussing. Part of the theory behind replacing the trial judge is the same reason we don't, as defense lawyers, handle our own appeals. We shouldn't be looking at our own errors. It's just cleaner when fresh eyes look at errors. And that largely was the final bottom line reason of why we wanted to include it, because we think that's just good policy, whether you're a judge, a defense lawyer, prosecutor. We're not great at evaluating our own errors.
All right, thank you. Anyone else that have comments or concerns, questions that they want to raise before we move on?
Judge Demuda. I'm sorry, Judge, I have to leave here in a couple minutes, but one thing I did want to raise is I don't think, I'm obviously very troubled by these provisions here, because I see this as effectively creating a parallel system that exists post-conviction with the expansive discovery rights discussed above. And then in conjunction here, this is essentially going to start litigation over any lengthy conviction over again once there's been a final judgment of conviction. That just starts the next stage in the proceedings here then. You're going to get a new attorney, a new judge, and they're going to do, relook at the evidence with more expansive rules of discovery here. And I would just say from a conceptual matter, I'm very troubled by that, because it seems to disrespect the work done by the first level by having such a broad scope of review on every case, not just death cases, that kind of comes through here. The second issue here, I don't think you can have this discussion completely divorced of the practical realities in terms of resources. County prosecutors and local public defenders are already overtaxed with the responsibilities they have. This creates a second set of a parallel system, like I said, right after conviction. And it's just going to take away from the good work that is done on the front end by all sides involved, because there aren't enough people who want to do appointed defense work, and there aren't enough people who want to take the low salaries of being a prosecutor out there. It's very difficult for people who want to do that long term. And so there's high turnover in both professions. And so I don't think you can necessarily divorce what should we do versus what can we do, because those questions, you can't answer one in a vacuum in these types of cases. So I would suggest that I think we should keep that in mind, that it's not just we're not contemplating our navel in an ivory tower. We have to be thinking in terms of what's the practical implication of what these types of recommendations would mean and what burden that would be placed. Because to Joanna's point, in terms of the alleged Brady violations that she's discussed, a lot of times when those are looked at, it's because you have a prosecutor with 60 cases, a defense counsel with 60 cases, and a judge who's trying to get through the docket. There are honest, good faith mistakes by everybody involved that could have been caught if we spent more effort on the front end, making sure the convictions were sound, rather than doing something like this, which is putting a kind of a backstop on every lengthy sentence out there.
Thank you. Can we do L real quick? Joanna?
Sure. And I can just say, I don't disagree with Doug that we need more resources at every stage of the proceedings. I think, the purpose of this task force is to recognition that at our current state, we do have these mistakes and need to address them. L was intended, and I'm seeing now it should be Criminal Rule 32.1. But there has been some litigation over whether 295321 is the exclusive way to challenge your conviction, and whether you can even file like a motion to withdraw a plea or a motion under Rule 33. That argument has been raised. I think the Supreme Court has addressed that with respect to Rule 32.1 and said that both remedies are available, and this just clarifies that the intention is that all of these remedies and any other appropriate remedy would be available.
Okay, anyone have a comment at this point on as it relates to L. And I think we just added the 0.1 after 32. We made that correction. And then M.
M is just the
John
last.
Martin, I'm sorry.
Oh.
Practical considerations also include the cost. Oh, yes. Want to say that, John, to everyone, or John has retort, Doug, a little bit. M, I see our time is running short, so we're actually a little past it.
M is a provision that was already part of 2953-23. And so since we merged the two statutes, I just carried that over.
Okay, so those are the proposed changes. All right, so yeah, in the hour, we're going to conclude at this point. So really, there are, as it pertains to 2953-21, I think the proposals are generally speaking in 6 categories: timing, hearing standards, right to counsel, discovery issues, petitions automatically reassigned, compensation. Actually, there's a 7th one, which is vetting of post-conviction motions to prioritize claims of actual innocence. There isn't a subsection that deals with that category. Is there, Joanna? Did you put in a clarification that pertains to that?
I'm sorry, can you repeat the beginning that pertains to what?
Vetting of post-conviction motions to prioritize claims of actual innocence.
No, I didn't include that express language.
Yeah, that's not in here. Okay. Okay, so we will, I just identified, I think, the 6 categories that these proposed changes come under. And at our next meeting on May 21, we will pick up our discussions and we'll address each one of those categories in succession. We'll also do criminal role 32. You had some changes in 32, if I'm not mistaken. Is that correct?
Yes.
Yeah, we'll do that as well. I do want to give the remaining task force members a heads up that as I had indicated in our previous meetings, I had hoped that we would have concluded this and would be in a position to discuss the ethics/training issue. And to that end, we have invited Lou Tobin, the director of the Ohio Public Prosecuting Attorneys Association, to come and present. I've not heard from him whether or not he's going to accept that. But if he does, we'll give him the opportunity to make argument relative to his their office position on their proposal for how they recommend a change in the ethical rules for consideration in managing or dealing with these post-conviction or wrongful conviction claims. And we will advise you accordingly whether or not he accepts our invitation or does not. It's also the chair's intent to invite the 3 county prosecutors, and as we get wind whether they intend to accept our invitation and present or not, we will advise you accordingly as well. All right, on that happy note, we will conclude our meeting. Unless there's other questions or comments anyone would like to make at this time. I don't see any. Thank you all for your participation. We'll adjourn at this time and see you back here on May 21 at 10.